Hello, everyone. This is Tom Fox back again with Matt Kelly for another episode of the award-winning Compliance Into the Weeds. Matt, why don't you tell our audience where you are today and the bombshell you heard this morning?
So I am in Dallas at the Society of Corporate Compliance and Ethics annual U.S. conference with about 1,200 other of my closest compliance peers, where we kicked off the conference this morning with a speech from Nicole Argentieri. She is the acting chief of the criminal division at the Justice Department. I think her full title is Principal Deputy Assistant Attorney General. But Ms. Argentieri is the de facto boss of the criminal division, and she delivered a speech this morning announcing some substantial updates to the department's evaluation guidelines for effective compliance programs. And she touched on a lot of issues. The new guidance is now updated on the criminal division website, if anybody wants to go and check it out. I have links to it on my blog. I'm sure, Tom, you have links to it on yours. Probably people are going to see it all over your LinkedIn feeds. But whether we want to talk about company speak up culture, artificial intelligence, compliance officers' access to data, budgetary and technology resources compliance teams get at their organizations, there was a lot of stuff that Argentieri touched on, and we will be able to talk about this for weeks on end, I am sure.
Matt, how about we start with the whistleblower incentive program? Because in addition to her remarks about its 1 month success, I thought she had a lot of information, and indeed the update, ECCP 2024 update, had some significant information about what compliance professionals need to do to basically protect whistleblowers. So you want to maybe start with that one?
I do, because with all due respect to AI changing the world, we knew that AI was something that the department would be addressing sooner or later. Now it has. But we did not necessarily know that these updates to whistleblower protection issues in the speak up culture would be included as well. And really, when you think about it from a compliance officer's perspective, the success of your program and the good graces of your relationship with the Justice Department and other regulators, that lives and dies on your speak up culture. So if we're going to pay attention to anything that the department just announced, pay attention to this stuff. So she did say that they will be looking at how a company supports its speak up culture. I think the direct quote that I plucked out was, "We will closely consider a company's commitment to whistleblower protection and anti-retaliation by assessing policies and training, as well as treatment of employees who report misconduct. We will evaluate whether companies ensure that individuals who suspect misconduct know how to report it and feel comfortable doing so." Now, that is all good, nice words to say. It's on all of the notes you would expect a Justice Department to hit when singing this song. But if you then look at the corresponding updates to the actual guidance itself, which there's some framing narrative around it, but really the guidance is a whole bunch of questions that prosecutors might ask your company about your compliance program, depending on the facts in question here. But some of these questions are, and I will just quote directly from the guidance: does the company encourage and incentivize reporting of potential misconduct or violation of policy? Conversely, does the company use practices that tend to chill such reporting? How does the company assess employees' willingness to report misconduct? So even if we want to pause there and step back for a moment, clearly there's a lot there about how you do at assessing the culture of your organization. Everything from incentive structures that maybe the HR team has concocted or the head of marketing or other operation divisions. How do those incentive and compensation structures or the incentives push or pull on internal reporting? What about those more intangible pressures that employees might face? Do I want to speak up? Do I want to keep quiet? So you could think about that. Tom, there was one other interesting set of questions here I wanted to call out as well. And again, these are questions taken directly from this new guidance. Does the company train employees on both internal anti-retaliation policies and external anti-retaliation and whistleblower protection laws? Again, Does the company train employees on internal reporting systems as well as external whistleblower programs and regulatory regimes? Now, that struck me as really interesting because the department is basically saying, are you training employees on alternative routes to speaking up that are legally available to them, even if those don't involve your company and your compliance program? Are you actually telling them you do have the right to go outside the company? You do have the right to go to the SEC or the Justice Department directly. Clearly, this is meant to make sure that they know that these whistleblower award programs at the SEC for many years, now at the Justice Department as well, to tell employees that these whistleblower programs do exist. And Tom, I've talked about this with you before. I wonder if Argentieri is hinting at some sort of criminal division look at retaliation clauses, which the SEC has clear statutory authority to enforce. And I'm still not entirely clear. I know what a retaliation enforcement sanction would look like from the criminal division, but I can't be the only one reading this stuff and be thinking there's retaliation issues are between the lines here. I'll stop right there, but there's more on whistleblower protection and whatnot. But even right there, what I just said, that's some pretty substantive stuff.
And let me pick up on directly on that last point because I think it points to a retaliation something. I cannot see a criminal charge being filed without an act with intent, but perhaps it could be. But it brought up one other thing for me, which is we have seen several court cases deal with external parties who retaliated against a whistleblower when they whistleblew in another company. So if you can't get a job, that is now protected activity. If your job duties are diminished, but if you are in any way blackballed in the industry, you have to train on that now. And if you do have to train on that, how far down the road do you go? So when I saw external, it opened up for me a lot of the new remedies that are available for people who whistleblow, do not go back to their company, but are retaliated by third party actors or third party companies or companies not related to the original company where they whistleblew. How far do you have to do that? Here's the other question I wanted to pose for your consideration. Do you now need to set up a separate group or procedure in your HR department for whistleblowers to watch them and watch what happens to them? You now need to segregate them out somehow and give them, if not special, you do have to give them protection, but do they have to have special protection and special oversight?
You could make the argument that the answer is yes, because here is another question taken directly from the guidance that jumped out at me. To the extent that the company disciplines employees involved in misconduct, are employees who reported internally treated differently than others involved in the misconduct who did not? So you have some sort of, I don't know, procurement fraud scam going on, and there's half a dozen employees who knew about it. Only one spoke up. What happens to that person? And I even wonder, how far down the road do we play this scenario out? Are you only making sure nothing negative happens to them? Do we want to see that whistleblowers are, in fact, have some sort of positive enforcement, like they get praised by the CEO? Do they get promoted for speaking up? Which, in theory, I think sounds like a great idea. If you want to encourage whistleblowing, you have to treat whistleblowers not just as protected, but upheld and praised employees. How are we going to do that? Tom, to your point about external parties retaliating against people who speak up, I have to admit, I hadn't really thought necessarily about that. But if that is a concept that DOJ wants to create or establish, I would actually be wondering more about the civil agencies, how they might take that ball and run with it, such as, I don't know, the EEOC or maybe even like the Labor Department or something like that, that they might start bringing civil enforcement actions on behalf of whistleblowers who feel like they've been wronged. But I'm still not clear on by who. You are we really going to punish companies for not hiring somebody they didn't want to hire. I don't know where that works. And then I am still stuck on this retaliation issue with the Justice Department, because I take your point that if they're going to bring an obstruction of justice charge against retaliation clauses, that to me sounds like you're using a machine gun to scare the squirrels off your property. It's a bit overreach. And let's remember, there's almost no examples of retaliation ever actually happening. The FCC can just bring enforcement actions on the civil side just by the mere dint of their existence. These things shouldn't exist. But in all instances, really, I don't think anybody's ever found more than one or two cases of retaliation really happening. I don't know what the criminal division is thinking there with regards to its awards program. But I mean, we could go for days on just the implications of this alone. And we still have three or four other big themes of this speech to get at, just to give people a sense of how far reaching this material was.
So you don't have retaliation cases because once you have a retaliation, it's no longer pre,
It's got to
it's
be
now
re.
re.
All right.
So that's why we haven't seen that in the past. But I can't leave this because I have to go into one other question they raised, which may go to the retaliation issue. And the question reads, how does the company assess employees' willingness to report misconduct? That is an incredibly deep dive question, literally meaning you have to assess your employees' willingness to even come forward, let alone all of the other topics that we've discussed. So I think the DOJ is very serious about this, and whether they see it as a problem or not, they're going to come down on it like a ton of bricks on companies who don't toe the line on this.
I mean, in theory, yes. I'm also curious, what are the sweeteners that they are going to offer? And certainly the corporate enforcement policy offers all sorts of discounts and potential for declination and things like that. So I look forward to the fact pattern that lets us see what a resolution with these issues discussed and explored would actually look like, and what sort of discounts do you get for what misconduct, because you were so thoughtful in trying to assess the corporate culture of your program, and how is that going to be discussed in a Justice Department settlement order? I have no idea yet, but like I said, there's a fact pattern out there somewhere that's going to let us chew over it, and I'd like to see that arrive sooner rather than later.
Do you want to look at compliance program access to data or some other issue at this point, Matt?
I think probably program access to data, or yes, I'm saying that right. Program access to data is probably the next big thing. Um, that is not a new concept with the Justice Department. They've been talking about this at least since the Trump administration, that they want to see that the compliance department has access to data across the enterprise that it needs. So again, back to the questions that the prosecutors might ask you. Do any impediments exist that limit or delay access to relevant sources of data? And if so, what is the company doing to address those impediments? Do compliance personnel have knowledge of and means to access all relevant sources of data in a reasonably timely manner? So I have a couple of different thoughts there. One, the part about what is the company doing to address impediments to access to data. I don't know that we have talked about this much lately, Tom, but I'm struck to see that over in the banking regulatory world, we have seen banking regulators now fine two major banks for failing to move in a timely manner to clean up and improve their compliance programs. From settlement orders that came about years ago, one was with Citibank, one was with Wells Fargo. Both times, the Office of the Comptroller of the Currency now, within the last 6 weeks, has dropped an enforcement order telling these banks to please get with it and speed up your improvements, all of which ties into these issues about access to data. Now, even absent the big Wall Street banks that are tied up with this, most other smaller companies outside of banking, they're probably still struggling to build the right IT infrastructure anyways, so the compliance team can get access to the data. Or is the compliance team supported by senior management in such a way that if they call up a business function and ask for the data, the business function will give it to them in a timely manner, or just give them access to their data lake or pool or whatever the euphemism we're using here these days, but just give them transparency into here's the data we have. Go knock yourself out. Does that sort of relationship exist? And then, Tom, there are a couple of more questions about what the actual resources are that the compliance team has, and are they getting their fair share? If every other team is getting an across the board increase of 20% to their IT budget, but the compliance team is getting a 3% increase, there better be a good explanation because the department is now going to start asking about why are you doing that? And I'll stop there. But yet again, much more deep, meaty stuff that is enough to keep us going for days just on this.
I absolutely agree. And the questions around the company managing the quality of its data sources and the company measuring the accuracy, precision, or recall of data analytics models is not only going to be, well, it's obviously critical, it's going to be incredibly difficult, and no compliance officer can do that. You're going to have to bring in some sort of resource, whether it be internal if you have a data scientist or other data expert, or more likely it's going to be some third party who can begin to assess that.
One thing that jumped out to me here, Tom, is that I think what the department is really driving at is companies that will come up with their big business expansion plans and then at the end say, oh, yeah, and compliance, you're going to have to catch up with this. Here's an extra 500 grand to your $501,000 budget. Go forth and do it. And I know plenty of people are just now thinking, I should be so lucky to get 500,000. But anyways, that they treat compliance as a bolt-on thing that they think about after the business strategy. And I think the department is trying to break that bad habit by asking these questions so that ultimately, because senior management will now be taking compliance so seriously, they're going to be thinking, okay, this is how we want to conquer the world, but let's bring compliance in to these strategic business plans right now so they can tell us how we will do it in a compliant manner. And let me point out, again, I will go back to my banking regulator friends, that this is exactly the constraint regulators put on Wells Fargo right now. Their compliance program is still a mess. It is still not being fixed. So the OCC told Wells, you must move more quickly to fix your compliance program, and you cannot expand into new markets until you get this fixed without our permission. I suppose maybe if Wells Fargo got permission to expand into a new market, new geographic market, new customer market, offering new products, what can they do? None of it without OCC's permission or proving that they have put their compliance program into an effective place, which it currently is not. So that is not a good outcome when regulators are clamping down on what you can do until you get the compliance program fixed. I think the department is here with this saying, don't make anybody get into that situation. Make compliance part of the conversation about these strategic plans from the start so that when you are ready to move into a new market, new customer base, new product launch, you have already thought about compliance and that you have already assured that they are properly resourced and have the proper data and systems to stay ahead of that expansion plan as it comes. I think that is where we're going with it. That's the through line, it seems to me.
Matt, it also occurs to me that the DOJ is moving companies and compliance programs towards a unified theory of risk management by asking the two questions under proportionate resource allocation. How do the assets of or tech available to compliance compare to those available elsewhere in the company? And is there an imbalance? Could the DOJ be pushing companies to balance that spend and give us really a more unified theory of or one look at risk management?
I mean, I don't know that they would go that far if we asked them that way. Like, I don't think the department is going to start setting budgetary expectations for CIOs across the country. I think instead they just want to make sure that the company is thinking this through. It's not necessarily the fact that because Everybody else gets a 20% increase. You get a 20% increase to compliance officer. You might not need one. So it might be okay that you do only get a smaller budget increase, or maybe you don't get one at all while everybody else gets a 2% increase. The point the department wants to say is just that if we are sitting across the conference table with you, looking at a circumstance, a set of facts, a violation of some kind, you actually have a good defensible rationale that you did the things you did for these reasons. And you can explain this is why we thought we only needed to increase compliance 5% while we were looking to double our expansion into the Far East market. Maybe you were thinking that you had better technology and you were planning some sort of use of AI where it would allow you to do more risk management at scale and efficiently. So you didn't actually need to hire twice as many people with a gigantic budget increase. I am pulling that scenario out of the top of my head, but so long as you can present a reasonable theory of the case about why the company did what it did with its compliance budget, even though you had a failure. Let's not forget, if you have made a good faith compliance effort, it's still okay to have a failure. They won't necessarily crucify you. It's when you didn't really think about it and the company didn't take it seriously and you could have anticipated these things, then suddenly the department, I think, is going to be wondering, what else did you think was going to happen other than having these unfortunate outcomes?
That seems like a good place for us to end this because we could probably go on the rest of the evening. Let me just end by asking, did Ms. Argenteria take any questions? And if so, what were they?
She did not take questions. She delivered a video address. I can say that nobody knew she was going to be delivering these remarks. We knew that she would be delivering remarks, but nothing so substantive. That caught everybody by surprise. And Tom, the only other point I will say before we close is that we shouldn't forget the artificial intelligence, which was something people knew would be forthcoming. Deputy AG Lisa Monaco said, I think it was back in March, that the guidance would be updated to include some discussion of AI. We can get to that in another Weeds podcast next week or something. Basically, please think about artificial intelligence risks before you rush to embrace them. That was one message. And second, AI is going to pose some really difficult fraud risks to companies from now forward forever. So companies will need to think about, are we updating our anti-fraud processes and controls to be ready for the onslaught of bigger fraud attacks driven by AI? That also is in the guidance. None of that is a terrible surprise. We've talked about the need for better AI risk management and governance before, and we will again. But honestly, I think that we're tiptoeing into AI. We've already been dealing with access to data and whistleblower issues for many years, and now you're going to have to deal with them even more with this guidance. So that's really the big stuff, in my opinion.
Well, Matt, I look forward to continuing this conversation.
Thanks, Tom.